She watched him leave and waited yet more time before leaving herself. He was still in the vicinity but hidden, and she waited for a while in the curtilage of the shop. When she moved away, the defendant emerged and followed her down Gloucester Road. She began to run, and she outran him. It is no hyperbole to say that her actions that night saved her life. This pursuit had lasted 21 minutes. That woman has not been identified. Before long, the defendant saw another potential victim who was inside a chicken shop on Romford Road. He entered and stared at her and put his hand spoke to the defendant. He put his arm around her and his hand between her legs before desisting. The two of them walked down a side street and paused together, but she then walked away. It is not known whether this was another encounter with a stranger or the defendant knew her. He has not said. For the next 50 minutes, he remained wandering around in Cranbrook Road, despite being minutes from where he was living. Shortly before 2 a.m., he came across a fourth woman who came out of a side road into Cranbrook Road. The defendant's attention turned to her immediately, and he followed her into Northbrook Road and beyond over the course of minutes. This was, in my judgment, another deliberate pursuit, and her actions on the CCTV, looking back over her shoulder and speeding up her walk, indicate that she also became aware of it. He overtook her and turned into one of the houses in the street, obviously waiting to surprise and grab her. He was disappointed because she happened to be making her way to a house on the opposite side of the street and was able to enter it safely. Coincidentally, Zara Aleena and her friend Barmini Bhatti had been in the Great Spoon of Ilford too earlier in the evening. But by 2 a.m. they were leaving a bar called Champ's Sports Bar in Chapel Road nearby. Ms Aleena decided to walk home. She did not have far to go. Her friend Miss Bhatti had called a taxi. As many women do these days, she called her friend to check that Zara had got home safely, but she never got any response. The defendant and Ms Aleena reached the junction of Northbrook and Cranbrook Roads at the same time. It was a fatal coincidence. He waited for her to go past and then crossed the road so that he was behind her. He followed her for some distance, getting to within a few meters of her until she reached number 268, a residential property on Cranbrook Road with a wide paved front garden or driveway. At that point, there were no other people on the street. The attack was captured on domestic security cameras. He grabbed her and pulled her backwards, one arm around her neck, the other over her mouth. She was dragged deeper into the darkness of the driveway, and it's clear that she struggled and fought him. But he had the advantage of surprise and strength, and he was successful in subduing her. He then parted her legs while she was on the ground, but still she fought and resisted, getting up again. Again, he attacked her and pulled her back onto the ground. She must have been rendered unconscious, because he then dragged her around without independent movement from her. He removed some of her clothing and sexually assaulted her. The security camera on the front of the house does not provide a clear image of these events. He kicked and stamped on her, his movements indicating that these were repeated, heavy assaults. He was not carried away, He had not been overtaken by an uncontrollable urge. It's clear that he was wholly aware of what he was doing. This is indisputably correct, because when he realized that someone was coming past the house on the pavement, he bent out of sight before resuming what he was doing. After satisfying his lust, he proceeded to destroy the woman he had just degraded. With sickening deliberation, he stamped on her. Then he left the driveway, but after walking a few meters, he returned and repeatedly stamped down on her body again, using the balustrade for balance. He searched her body again and left for a second time, carrying things of hers. Still not finished, having walked away this time further, he again returned to Ms Aleena and bent down by her body before stamping on her again. This abduction, sexual assault and murder lasted just 9 minutes. He had carried away her phone, keys, purse, leggings and underwear, and they were found abandoned nearby. He was captured on CCTV at the fair, where the caravan was located, with bloodstains on his clothing and trainers as he returned. Zara Aleena's body was found by 2 couples walking past, and emergency services were called. Some of those members of the public have been traumatized by what they saw. The court commends their swift and compassionate actions in seeking help. Ms Aleena was desperately injured, struggling for breath, and her life was in danger. All that could be done was done by the medical professionals who answered the 999 call. They tried to save her life on the driveway for over an hour. She arrived at the Royal London Hospital after 4 a.m. and the work continued, but by 9:58 a.m. she was dead. She had suffered 46 separate injuries. These included severe blunt force trauma to her head, deep lacerations to her scalp, bruising to her lips, ear, eyes, nose and jaw. She had suffered genital injuries. The severity of the violence caused traumatic brain injury. She died because of the brain injuries and prolonged neck compression. She had been stamped and strangled to death. The defendant had left 2 fingerprints in blood on the balustrade. Through intelligent and swift work by the Metropolitan Police, he was quickly identified and arrested on the 27th of June at his caravan in Valentine Park. He made no coherent response to arrest. His blood-stained trainers and jeans were found secreted in the caravan park. He had hidden them there in the afternoon of the 26th of June. His demeanour on the relevant CCTV footage from the site that afternoon suggests no cares, no regrets, no contrition. At the police station, he said he was on medication for ADHD and suffered from a split personality disorder. He also claimed to have been bitten by a dog. He refused treatment and threatened officers at the station. He made no comment in 3 police interviews and exhibited utter disrespect for the situation he was in, given what he knew he had done so recently. Nothing a judge says can make any difference to what happened to Ms Zara Aleena. No sentence of the court can bring her back. The defendant had the physical advantages of strength and surprise. In everything else, she was better than him. She was talented, spirited, intelligent, and kind. Spending the evening with her friend, she had done nothing wrong, taken no misstep, shown no lack of sense. She was simply a happy, healthy woman, living her life in what most Londoners think of as the best city in the world. The defendant has been brought to court today, but has refused to come up to this courtroom. He has given an excuse that he doesn't want to revisit the events he is responsible for. It's agreed that his non-attendance is voluntary and it is appropriate to sentence him in his absence. But the defendant's decision not to come up from the cells to court to hear the devastating impact of his crimes shows that the man who took Zara Aleena's life has no spine whatsoever. Murder carries a life sentence. I have to determine the minimum term to be served in accordance with paragraph 3 of Schedule 21 of the Sentencing Act 2020. It should be clear to everyone that this figure is just the minimum, and it will only be when the parole board considers the defendant is no longer a risk that he can be released. That day may never come. The prosecution submits that this is a case in which the seriousness of the murder, considered together with the sexual assault, is particularly high. The defence agree. The starting point for the court's determination, both sides agree, is therefore one of 30 years. Mr. Glasgow King's Counsel submits that accounting for the aggravating and mitigating features and for the guilty pleas, this case merits a sentence well in excess of the minimum term. Mr. Carter Stevenson, King's Counsel, disagrees and urges the court to pass a more moderate minimum term in all the circumstances. In this respect, the specific disputes I have to resolve are fourfold. Firstly, the prosecution and defence agree that the evidence is the defendant was planning to commit a sexual offence, and there is no sign of significant planning or premeditation for murder. However, I do not agree that this is a case of someone seeking what has been described as an intimate encounter. That is far too neutral a term, albeit understandable. Most of the defendant's behaviour in the 2 hours before he dragged Zara Aleena off the street reveals a resolve to find and attack a vulnerable female. He confronted or followed several women. I am sure that the defendant intended to sexually assault a woman violently, using such force as required to achieve submission and to frighten her. Although I do not sentence on the basis that this was a premeditated murder, I am also satisfied that he was quite prepared to kill if necessary. As it turned out, he decided it was. Secondly, although he has no previous convictions for sexual offences or crimes of serious violence, the prosecution relies on records of his previous aggressive behaviour as an aggravating feature. The evidence is of 4 specific incidents since 2009 and a large number of incidents of aggression in prison. I ignore the earliest incident provided by the prosecution. But in 2010, his partner alleged domestic violence. She told the police that he had assaulted her, pushed her down the steps, pulled her hair and strangled her. She bore visible injuries. He was arrested and he gave an account to the police largely in line with what she had said, but he excused himself because she had been, quote, going on, and as a result he lost his temper. Between May 2018 and June 2019, he abused another woman with whom he was in a relationship soon after it began. He would slap her, punch her, beat her, kick her in the ribs and drag her along the road. In February 2020, while in prison, he threatened to kill a prison officer who had spoken to him after he'd damaged his cell. He said he would cut off his head and open him up. This sort of threatening attitude and behaviour is his default presentation. Intelligence reports disclosed to the defence demonstrate that on the 20th of December 2015, whilst located in the segregation unit of a prison, he made threats to carry out very serious harm to a prison officer who was female. They also include a report that in March 2017 he became abusive and aggressive when asked to remove photographs from his cell wall by another female officer. to whom the defendant also made threats of really serious bodily harm, including stabbing. He said, "I've stabbed govs before, check my file and watch what I do to you." His record of adjudications in custody shows that he had 223 adjudications between August 2010 and June 2022, 165 of which resulted in charges, 139 resulted in verdicts, and 169 resulted in sanctions. Among them are numerous adjudications for committing assault and for using threatening, abusive, or insulting words or behaviour. The Police Intelligence Unit incidents for a prisoner report records 102 incidents for Jordan McSweeney between August 2012 and April 2022. Amongst these incidents are serious assaults on other inmates, improvised weapons being found in Jordan McSweeney's possession, and general disobedience. I remind myself that it is only that which I can be sure of to the criminal standard of proof that can be relevant to the decision I must make on a minimum term. I am sure to that standard that the defendant is a pugnacious and deeply violent man with a propensity to violence. In my judgment, this material is also relevant to the extent that it demonstrates that his behaviour on the night of the 26th of June 2022 was not an aberration. It was a steep and sudden escalation of violence which had simmered in his life for many years. Thirdly, I have to determine whether this is a case in which I am sure that the degree to which Ms Aleena suffered mentally or physically before her death is an aggravating feature. It is argued that she is likely to have been unconscious very early on and during much of the attack. That she remained unconscious is speculation, and there is evidence contrary to that suggestion, including the need, as he saw it, for the defendant to return to the victim twice after initially leaving her. She survived 8 hours after the attack. I am sure she will have suffered inordinately, and this is an aggravating feature. Fourthly, I have no doubt Jordan McSweeney intended to kill Zara Aleena. The nature of his attack, stamping on her head, and the fact that he returned twice drives me to the conclusion that this was a determined intention to kill. Finally, is there any degree to which culpability for this murder is lowered because of a mental disorder or disability? Mr. Carter Stevenson submits that I should have regard to the defendant's statement at the police station that he has attention deficit hyperactivity disorder and personality disorder. As I observed to counsel, the court has no psychiatric report from any expert who examined the defendant. I have considered the report of the psychologist, Dr. Black, very carefully. I bear in mind all the mental ill health identified therein, which counsel has summarised as making the defendant someone who struggles in the community and has real difficulty in making and maintaining a healthy social life and relationships. Despite the brokenness the defendant has experienced, I do not consider that there is any cogent material upon which I can conclude that the mental health issues which he undoubtedly has, or the antisocial conditioning from his upbringing, are capable of reducing his culpability to any material extent. I sentence him on the basis that his mental faculties were such that he bears full responsibility for his actions. The presence of the following aggravating features is agreed: the location and timing of the offence, in public in the early hours of the morning, witnessed partly by members of the public, and the attempts made to dispose of or conceal evidence, such as the blood-stained clothing and shoes. Two other factors which I consider to be important require attention. Firstly, I am sure that the taking of Ms Aleena's mobile phone was a deliberate attempt to prevent her calling for help or giving a description of what had happened to her before she died. And secondly, he had shortly before been released from the defendant's most recent sentence. The revocation of his licence on the 24th of June was placed on the police national computer on the 25th of June. In my judgment, he committed this offence in the expectation that he was likely to be returned to custody soon in any event. Apart from the guilty pleas, I find no mitigation. He has never expressed any remorse or demonstrated empathy for the outcome of his behaviour in evidence. He cried at the police station, but this was after his arrest for murder and rape, and it was not accompanied by any expression of sorrow for the impact on anyone else. His licence has been revoked and he has been serving the remainder of his previous sentence while on remand, so there are no days to be counted against the sentence I pass today. I have taken care to avoid double counting. The sexual assault is a Category 1A offence because the defendant used violence and threats and abducted the victim from the street. There was a significant degree of premeditation because he wandered around the area until he found the ideal circumstances in which to commit the offence. This was a particularly violent sexual assault committed at night in a public place on a woman out alone. The defendant removed Ms Aleena's knickers and caused injuries to her genitalia, as well as the injuries that led to her death. The sentence for that offence of sexual assault, had I been dealing with it alone, would have been 6 years imprisonment. Taking into account his history of offending, had there not been a guilty plea, I would allow 1/3 discount for the plea. I take the view that this offence is already incorporated into the minimum term for murder because I have taken the higher starting point of 30 years and I reflect the aggravating features of it in the minimum term for the murder. Having been arrested on the 27th of June, the defendant was charged with murder and rape on the 29th of June. On reception in prison, he indicated that he could not comprehend that he had done what he had done. He appeared for a preliminary hearing on the 1st of July 2022, and his PTPH was set for the 30th of September 2022. Prior to the listing, the solicitors acting for the defendant wrote to the court to inform them that they had not received an expert report commissioned from a psychiatrist because the defendant had not seen him. Furthermore, owing to the industrial action being taken by the defence bar, his instructed advocate would not be present. Accordingly, I adjourned the hearing to the 19th of October, and an extension was given for service of the defence statement. The defendant failed, without a reasonable excuse, to attend 2 appointments with the psychologist on the 21st of September and the 3rd of October. His solicitors wrote to the court again to request a further adjournment. When the case came before the court for PTPH on the 19th of October, the defendant refused to attend, and it became apparent that he had not attended a conference that had been arranged with his solicitors. The defence were directed to secure the services of a psychologist who could provide a report as soon as possible, and the PTPH was adjourned to the 24th of October. On that date, the solicitors still did not have a report, and the PTPH was adjourned once again to the 11th of November. In the report of Dr. Black, which is dated the 26th of October, and which was, I'm sure, in the hands of the defence soon after that date, the defendant suggests that he did not remember what had happened, and he could not believe what he was seeing when shown the CCTV in interview. In fact, at the police interviews after arrest, the defendant affected a bored and disinterested facade. The defendant was not produced at the next hearing because he tested positive for COVID. The PTPH was put back to the 16th of November. Despite a direction that he attend in person, the defendant refused to come to court on the 16th of November, and a video link had to be arranged. The defence took instructions from the defendant and approached the prosecution about potential pleas, and this was indicated to the court. The PTPH was adjourned to the 19th of November, and on that occasion, the defendant pleaded guilty to the preferred 2-count indictment, murder and sexual assault. I accept that the defence solicitors commissioned expert reports to ensure there was no psychiatric defence to the charge of murder and to ensure fitness to plead and to be tried. These were responsible steps in a case of such gravity. I also accept that because of the action taken by criminal barristers, the defendant was not able to receive advice from junior barristers or King's Counsel until October this year. I reject the suggestion from the defence that because he was heard on a prison phone telling his mother that he was banged to rights, he should be taken to have indicated at a very, very early stage that he would accept responsibility for the killing. He never indicated this to the court until the 16th of November, and at stages, his non-engagement frustrated the work being done on his behalf. In addition, as Mr. Carter Stevenson accepted in his written submission on sentence, he caused some additional delay through taking a belligerent attitude when required to come to court, including telling the jailers on one occasion that there was no point in attending a hearing at which he was required. Overall, my conclusion is that the defendant is entitled to less than the maximum discount on the murder count, and I would allow 1/8, although given the length of the term I will impose, the maximum discount allowed can be 5 years. Considering all these features, after a trial, the minimum term would have been 43 years. I allow 5 years, as I have said, for the plea of guilty indicated by counsel on the 16th of November, a few weeks before trial. A sentence of 4 years concurrent is imposed for sexual assault. The sentence for the brutal, sexually motivated murder of Zara Aleena is imprisonment for life. The defendant will serve 38 years as the minimum term. The court would like to thank counsel and also to commend Mr. and Mrs. Condor, Georgina Woolard and Maria Bergen.